Hi everyone, the world sucks right now, so I have just given up and went down a Superman rabbit hole. The rabbit hole deals with James Gunn's Superman movie that's coming out this year, and the lawsuit that it got itself into on January 31st of this year. In the lawsuit, the estate of Superman co-creator Joe Shuster sues Warner Discovery over the fact that the copyright has reverted back to the estate in countries like the UK, Canada, Ireland, and Australia, with the estate's lawyer Mark Toberoff leading the lawsuit. Remember him for later. Saying in his own words about the lawsuit and Warner Discovery that they continue to exploit Superman without the Shuster estate's authorization. But this was not the only lawsuit over Superman, because through my research, it led me down an 80-year rabbit hole of copyright lawsuits, and now here we are with the video. Part 1. Here's the summary of the origins of Superman from its creation to its publication in 1938. Two high school friends from Cleveland, Jerry Siegel and Joe Shuster, came up with the idea for the Superman comic. Siegel would write and Shuster would do the artwork for the comic. After that, for the first 5 years, they would pitch the idea at first as a comic strip, which then changed when they took the idea to National Periodical, which is now known as DC Today. DC thought it would look good in a magazine format that we now know today is a comic book. And, there was nothing else that they suggested or asked for, nothing shady, and Siegel and Shuster never got screwed over afterwards, and this is no joke at all.
We're waiting.
In all seriousness, Siegel and Shuster had a copyright on Superman while pitching around, but when they came to DC, they sold that copyright to DC for $130. This decision, I would never put it on the fault of the creators. When people always say that you, as a creative person, be that music, writing, art, acting, stupid YouTube essays or whatever, that you need to read your contract or agreement, get a lawyer to read them, or just not sign them in general. Those people are saying that because of stories like this. So if you look at the agreement that Siegel and Shuster signed, it is so complicated and confusing in wording that what they thought it was an employment agreement, an exclusive agreement, where they would still get some royalties off of the comics that they were making, but instead it was actually them selling over everything of the copyright to Superman. I, the undersigned, am an artist or author and have performed work for strip entitled Superman. In consideration of $130 agreed to be paid me by you, I hereby sell the transfer such work and strip. All goodwill attached thereto and exclusive rights to the use. The other part of selling the Superman copyright is the problem that the copyright affects Siegel and Shuster in court. Part 2. The first time Siegel and Shuster sued DC was in 1947, with the court siding with DC, with both Superman creators paying $94,000 to DC. DC also did have to pay Siegel and Shuster over the property of Superboy, but that's not really the main story, so it's the left out. It's the left out of this one. The second lawsuit happened in 1969, with the court again siding with DC. Okay, to understand why this happened, we need to talk about the Copyright Act of 1909. I'm not legal eagle in both looks and being a lawyer. I also know this act on a surface level, which basically means a few hours to a week of research. That also goes with another Copyright Act we'll talk about later. I encourage you to actually do your own research from the links I have in the description. Basically, there are certain parts of the Copyright Act of 1909 that are hard for someone who sold their copyright to a person or company and then they started to work for that company on the copyright that they sold, what is called work for hire. In selling Superman to DC, the first published work of Superman that would be protected under that copyright law and act would be Action Comics #1, and not the unpublished comic strips that Siegel and Schuster made to pitch around to other companies. This meant that Action Comics #1 and so on is work for hire for the owners of the copyright, DC, by the employees Siegel and Schuster, which would mean that they wouldn't be recognized as owners of that copyright, which was the reason why they lost the 1947 court case. Another part of the Copyright Act of 1909 is renewing for copyright. Now, renewing for copyright work is that after 28 years from the first publication of that work, the owner has to renew again. In this case, after Action Comics #1 got published in 1938, DC would have to renew again in 1966, which led to Siegel and Schuster applying for renewal in an attempt to get ownership back, but were sadly beaten by DC. The lawsuit of 1969 being based on that, with the court explaining that the reason why they sided with DC was because when Siegel and Schuster sold Superman, they also sold their right to renew to DC in the copyright sale. After this, in the 70s, Jerry Siegel and Joe Shuster were not working in comics. Siegel was working as a typist for a mailroom in California, and Joe Shuster was almost blind in a nursing home. Though there was some kind of luck when in 1975, Warner Bros., along with director Richard Donner, would announce that they would make an adaptation of...
But the world will know him as Superman.
During this time, the Superman movie was announced. A campaign to get Warner Bros. And DC to compensate Siegel and Schuster was led by Batman comic book artist Neil Adams and Jerry Robinson, the latter of which got screwed by disgraced Batman creator Bob Kane. After hearing about Siegel and Schuster's situation, Warner Bros. And DC gave them a stipend of $20,000 and medical benefits, while also giving them credits for creating Superman in the Superman movie. In the 80s, though, there was no lawsuit between Siegel, Schuster, and DC until Siegel and Schuster's heirs got involved in the 90s after their deaths. This is kind of where the story gets a bit complicated, though, for two reasons. The first reason, in the fight over the ownership of Superman, it kind of becomes lawsuiting for lawsuiting's sake, in my opinion. I use my opinion because I don't want to get sued because I have no subscribers and barely any money. Look at my Scooby-Doo wallet. It's all empty. It's all empty. This began in 1992 after Joe Shuster's death, where his sister and brother inherited the rights to Superman, which led to his siblings signing an agreement with DC where the siblings would give over the Superman trademark to DC. This meant that they got a $25,000 stipend while also receiving benefits from that agreement. But there was a problem with the agreement when they wanted to do something that would allow them to terminate the transfer of Superman. Now, to understand terminating a copyright transfer, we're going to look at the Copyright Act of 1976 for this. I'm going to try not to make this complicated. I mean, I'll try. Basically, terminating a transfer is if someone creates something under work for hire or sold their copyright, they have the right to terminate the transfer of that copyright that they sold. As an example, in 1996, when Jerry Siegel died, the Siegels used this termination transfer, but because the Schuster signed that agreement with DC, they couldn't use that termination transfer because they basically sold the termination transfer rights over to DC in that agreement, which made them hire Mark Toberoff. See? Told you he come back into the story. See, I told you. Mark Toberoff is an attorney mostly for intellectual property over comic books and movies like Beetlejuice, A Christmas Story, and Predator. He's also a movie producer on the sequels to Beetlejuice, A Christmas Story, and Predator, while also being Elon Musk's attorney for the bid on OpenAI. The Schusters found Toberoff to represent them, with Toberoff somehow calling the Siegels so he can end up representing them as well. Though here's the thing, is that at that time the Siegels sold their 50% of Superman to DC for $5 million, a $500,000 stipend, and percentages on both movies and comics of Superman. But the Siegels probably didn't keep that deal when they had lawsuit after lawsuit after lawsuit against Warner Bros. And DC through the 2000s to the 2010s, alongside the Schusters being represented by Toberoff, which through these lawsuits, DC had allegations and claims that Toberoff might have wanted to represent the Siegels and Schusters so he and his billionaire friend could get the rights to Superman to make a Superman movie. With these lawsuits never getting closer to having ownership of Superman, which is why it seems like just lawsuit over lawsuit's sake. Though I think that with the Siegels and Schuster, there is a side of honor. I'm not blaming them for lawsuiting. I don't think that they are to blame for that. They lost a family member, and I do think that they really want to get their rights back to what their family member created. I would also advise anyone to not go after them or anyone I mention in this video. Okay, thank you. Love you guys. Bye. There is also the fact that the Siegel family in those lawsuits did get the copyright and ownership of the Action Comics that Jerry Siegel worked on, which brings up my second reason why this part is pretty complicated. So let's say that the Siegels and Schusters actually had the ownership of Superman. What would they do with it? Would they handle the comics themselves, have DC do that, or some other publisher? How would they handle the movie, or who would they choose to handle it? Of course, I do think these lawsuits were mostly over just royalties, or bigger royalties for Superman than just ownership, but it could also be for ownership over Superman as well. Which brings this thought of what would happen if it was that ownership. Where it could be that someone other than DC and Warner Bros. Takes the movie and publication rights and changes Superman. You can think that that's a good thing or bad thing. But another thing too is, because Superman has been around for 80 years, is changed from what Siegel and Schuster first created, and has basically found its way to being more other authors' works than just theirs. So if it were to go to other people, would it become Siegel and Schuster's work, or would they just change it altogether? Now we're back on the focus of this video, the 2025 lawsuit where the Superman copyright reverted back to the Schuster estate in other countries. How it got reverted back to his estate is because of the Berne Convention. The Berne Convention, according to the World Intellectual Property Organization, is the protection of work and the rights of their author. This was created in the EU, with the US joining in 1988, then went into effect in 1989, where the copyright work of American authors would be protected in other countries. The Berne Convention used by Toberoff as his argument, saying that 25 years after Joe Shuster's death, Superman reverted back to him starting in 2017 for some countries, then Canada in 2021. Now, this seems like whatever happens with this lawsuit in any way doesn't seem to be pushing back the original release of July 11th for the Superman movie in the US and internationally. There's also no news about any negotiations between these two parties, so only time will tell if the Schuster estate will get payment for this movie, or if it just becomes another lawsuit.